Hi, everyone. Welcome to this week's edition of Facebook Live with Joseph and Hall. I have two of the other attorneys in the office with me here. You've met them before, Luke Neerman and Rylan Warner. We're going to give you some updates today on the universe of immigration law this week, what's happened this week. And then, of course, as always, we are here to answer any and all questions that you have. So please feel free to put your questions in the chat box and we will answer them as we go along. So who wants to start? Luke?
I'll start.
Okay, great. Rylan, why don't you talk to us about the EAGLE Act and what was introduced this week?
Yeah, so on June 1st, just 2 days ago, HR 3648 was introduced, which is the short name for the Equal Access to Green Cards for Legal Employment, or the EAGLE Act, that was introduced to the House of Representatives by Democrat Zoe Lofgren and Republican Joe Curtis. And so this legislation, it aims to eliminate the 7% per country cap on employment-based immigrant visas and raise the per country cap on family-sponsored visas from 7 to 15%. So that would be a huge thing, because since 1990, no country can receive more than 7% of the total number of employment-based or family-sponsored preference visas in a given year. And that means that countries with larger populations, like India, are only allowed they're only allotted the same amount of visas as countries with much lower populations. So even if a person has excellent qualifications and may be great for the U.S. economy, they might be still unable to get an employment visa if they're coming from a country with a larger population like India. So this bill wants to get rid of that cap so that we can get better qualified people into the country to work for us and to help make the country better. And it's not the first attempt that they've tried at this bill. Previously, it was called the Fairness for High-Skilled Immigrants Act. And in December 2020, it passed by unanimous consent to the Senate, and it also passed the House, but there were two different versions of the bill, and the period for it to actually come together and become law, it lapsed before the Senate and the House versions could be reconciled and made the same. So I was wondering, Jeff, if you thought that maybe it has a better chance of actually coming to be this time, or if maybe we'll stay at the same spot.
Well, I mean, first of all, given there were some serious concerns with the previous bill. The first concern was there were some provisions that were added that, number one, Section 8 on the previous bill, which was that Ryland referenced, would have put a cap on the number of adjustment of status applications that could happen from H-1B or H-4 status. And so that would be disastrous, obviously, because a large portion of the people that are seeking green cards in the visa bulletin are coming from H-1B to adjustment. So it would have put them out of the equation, which obviously we oppose greatly. More concerning was they added a Section 9, which would have prohibited adjustment of status for Chinese nationals. So the last iteration of this bill was racist. It basically benefited Indians, which is good. I mean, Indians have always been disadvantaged by the visa bulletin because of the percentage cap. And so they've always been disadvantaged, but it doesn't seem to make sense to me to advantage Indians at the disadvantage of everyone else. And when they added the poison pill of the Chinese nationals, that was enough for me to make it, not a palatable bill. As far as whether this one will pass, given the current climate, there's little bipartisan support for anything involving immigration. Nobody wants to touch immigration. And so, to be honest with you, I don't see this bill going anywhere. I think it's being introduced there's a lot of vocal advocates and supporters of 386. If you are on my Twitter feed, you know that they're very active on my Twitter feed, and I think that this bill is introduced to placate some of the people that supported 386. But I think it's going to have a harder time passing because, number one, the House is more educated about the provisions and what the visa bulletin means, and so they have an understanding of that this will benefit some to the detriment of others. Next, there's a lot more included in this bill than than what was included in the last iteration. And so I can see, Republican senators having a big problem with some of the additions in this bill. And frankly, they're just not willing to cooperate on immigration anyways. So even if we're to pass the House, it's a dead end in the Senate for sure. Two of the major supporters of the bill from the last iteration, Mike Lee, who is the key Republican sponsor, for some reason is not supporting this bill and seems to be backing away from legislation. And, since the Scott amendments were stripped from this bill, he will not be supporting it either and probably will be advocating against it. So I really don't think that there's a good chance that this bill will pass. It's good to talk about it, however, because it highlights and lets legislators know that there is a huge problem with the visa bulletin. It just doesn't work, and we all know that. But how we fix it is a matter that's going to be very complicated, and we're going to have to balance a lot of interest to do that. So.
Oh, man, you really shot my optimism there.
Yeah, I mean, a couple of other things that in the bill that are worth noting is that it does increase the family. It's not just about employment. It increases the family limits to 15%.
Yeah.
And it eliminates the country limitations, but that's over like a 9-year transition period, right? And they reserve a certain amount. I think it's 6% of the visas for consular processing in the first 9 years, and they reserve about 5,000 visas for nurses and physical therapists for the first 7 years. So, there are some good provisions of the bill that take into account, the need for visas to be distributed to consular processing in addition to adjustment. There's also some bad stuff with regard to H-1Bs. There's going to be, new posting requirements, new petition requirements, new authority for investigations by the Department of Labor for LCA violations. So, there's a lot of things that we're going to need to weigh through in the bill and talk about before we can indicate whether we support it or not. One other provision is it does allow for early adjustment for non-immigrants to apply for adjustment of status if their I-140 has been approved for at least 2 years and a visa is not available. So, that's a good provision. It allows for early adjustment. That is not a provision that is palatable to the Republicans, and I think that could be problematic. So,
yeah.
All right. Well, great update on the EAGLE Act. We will keep you updated as this progresses through the House and Senate, and let you know if my prognostications are true or if it really will pass. So, great. Let's see. What about the migrant protection protocols?
Yeah, so
this week.
June 1st, we had Secretary Mayorkas also issued a notice just indicating that the MPP program, this was dubbed the Remain in Mexico program, has been officially terminated. So this program was started back the end of 2018. And what it did was it basically, forced people who came to the southern border who wanted to apply for asylum, they were returned to Mexico. And the intention was that they would stay in Mexico while they pursued their asylum claim in U.S. courts, and that the U.S. government, CBP, would facilitate their entry into the United States just for very temporary periods of time for them to attend their asylum hearing. So Secretary Mayorkas, he officially terminated this program June 1st. And there's a lengthy memo that he issued. And really, they found that this was just a total failure. This program did not work. So there were about 68,000 people that were part of this program, MPP. So 68,000 people who came to the U.S. who were trying to apply for asylum were returned to Mexico. Some interesting statistics here. They, one of the goals of this program was to increase the speed and the efficiency at which these asylum hearings would occur. And they found that, in some cases, the hearings did go very fast. But that might have been in large part due to the fact that people weren't able to attend their hearings. The logistics of coming into the United States for this temporary period of time to attend their hearing were just incredibly difficult for a lot of people. The housing that folks were in Mexico was very difficult. The environment that people were forced to stay in. And so a huge number. So 44% of court hearings resulted in absentia removal orders, which happens when people just don't attend their asylum, when they don't attend their court hearing. So while those cases were processed swiftly, the outcome was not really ideal, what we were looking for. Secretary Mayorkas also found that this was just a huge drain on resources for CBP. So CBP officers were tasked with facilitating the entry into the U.S., and it really kind of detracted from what their other responsibilities and duties were. So this program has been officially ended. DHS has been working to try to facilitate the entry of some people who are placed in MPP into the United States, where they can stay while they pursue their claim in immigration court. So definitely a positive development that the MPP is over. And yeah, just kind of shows it was a terrible program and really failed on a lot of fronts.
Awesome. Thanks. And if you have questions about it, feel free to post them in the chat box. Let's talk about just generally visa delays, what's going on at the consulates, priorities. What are we seeing at the consulates in terms of delays and refusals and all that?
So I know, Jeff, that you were talking about on Twitter, you were talking about the London cancellation of all routine visa appointments. That's going to be starting in August 1st. And so you had heard about that through an email from travel.gov, and it's still kind of ambiguous whether it will be, is it not?
It's confirmed. It's confirmed. There's been reports of numerous clients around the country from different lawyers that have had August and September NIV appointments canceled. Okay, so the statement is really not clear, the scope of the shutdown. But what I can tell you is that we have not seen immigrant visa shutdown. And the good news is for K1s is that K1s are processed by the immigrant visa unit. So please enlighten me if you're one of our K1s and your appointment has been canceled. That's something I really need to know. But at least what we know for now is that it's only NIV appointments. We don't know when it's going to end. It's August 1st indefinitely. So what most lawyers are telling their clients is that look for an NIV appointment early next year, if your employer is willing to hold on that long. I mean, it's really nonsense. The other trend that we're seeing is basically a refusal to process E2s. E2s are visas that are for investors, people that are coming to this country to start a business or invest in a business, employ U.S. workers. And those are, the interesting thing about the E2 visa is that the Department of State actually has original jurisdiction over those visas. They're not a USCIS visa. It's actually a Department of State status and visa. So you apply for it at the consulate. The problem is that the consulates are not adjudicating E2s, and there's no indication of when that's going to change. So, we've talked to you before about the 4 tiers that the Department of State set out. I think it was on April 8th, where they, set out the different tiers. And what we know is that E2s are nowhere on there. So, keep us reported if you have other types of cases and you're having troubles getting scheduled for NIVs at any consulate around the world, because we are monitoring it and reporting back. So. And then, so we've talked about London. I won't go into detail about London, but it's a staffing issue at the end of the day. I mean, they just, they have staff that has been working part-time during COVID. They were already understaffed going into COVID. And so it's sort of a perfect storm that they don't have the capacity to handle the visas. Now, that being said, there are creative solutions that other agencies have done, such as video interviews or waiving interviews, especially in the case of a renewal. If a person already has a status and they're just going to renew their visa, that should be routine. It shouldn't require an interview. So there's a number of things that consulates could do to shorten the timeline. But at least at this point, Department of State is the only agency that we're dealing with that has taken no action and has no plan. So that's why we've sued them multiple times. Anything else before we go to some Q&A, guys?
I would just note, the National Visa Center, or I'm sorry, Department of State has started to publish a report on the immigrant visa backlog. So we have statistics for April, and then we have statistics for May. New stats aren't out yet, but this is just showing that the immigrant visa backlog is continuing to grow. So we're hopeful that some of these lawsuits that we filed will kind of push Department of State to take some more creative solutions in addressing this. But
yeah,
an issue for a lot of folks.
All right, well, let's go to the questions. Rylan, this first one is for you. Tell us what's going on with the Egypt K1 Yaqub lawsuit. Could be Blinken.
So that one's Jennifer. I'm the spousal one.
Okay. I can tell you that there's really not a huge update on this case. It has been assigned to an attorney. What we know is that the Department of State has basically instructed all local U.S. attorneys to not settle mandamus cases. They're flooded with mandamus cases. When we say flooded, when we last checked, there were about 70 cases, right? So flooded is a relative term, but they say they're flooded with litigation. And so the Department of State headquarters has ordered U.S. attorneys not to settle these cases anymore. So what we know about all of the mandamus cases is that we probably are going to look at a 60-day wait before the government submits a response to our complaint. We also know from our other cases what those arguments are going to be, right? They've already submitted that motion to dismiss in other cases that we have, Go and others. So we know the arguments that they're going to make. We can anticipate them. They're not strong. They're really not. One of the arguments is that the judge has no jurisdiction over the case because even though we've sued Blinken, the head of the Department of State, rather than the individual consular officer, and the individual consular officer is the one that makes the decision. So it's absolutely nonsense that their boss, Anthony Blinken, has no authority over them making decisions. It's just simply nonsense. These are the kind of arguments that they're reaching for to try and get the case dismissed. So the standard for a motion to dismiss is really high. I do not think these cases are going to get dismissed. I obviously can't guarantee anything. A lot of it depends on the judge. So I can't guarantee anything, but I think these cases will be dismissed. Now, whether having survived a motion to dismiss, the government will be in a different position in terms of settlement is yet to be seen, right? So, they've instructed them to go through the motion to dismiss, but we don't know if they've instructed them to go all the way to summary judgment. So it could be that if we win a motion to dismiss, that then the government is in a better position to settle with us. So, wait the 60 days, be patient. We'll keep you updated, but we really have nothing to do on the Egypt or the other mandamus cases until the government responds to our complaint. What I would like, however, is for you to continue to fill out the status reports and let us know if you do get scheduled for interviews. And if you get your visa, we're dismissing those plaintiffs from the case. So please do give us updates on interviews and visa issuance. All right.
Jeff, I would also like to add that I know that previously we would have really liked if we get email correspondence from the embassy, like updated email correspondence saying that they still will not forward it to the embassy, even though there has been this national interest exception made for K1s. I've seen it in other cases that they're still getting emails saying we're not going to send K1s. So if you're getting emails like that, please send them our way.
Yeah. I don't know if you know this. I know that you've had you've been doing some work on Go. Aaron's not on the call today, but do we know any Go plaintiffs? Go v. Blinken is the DV 2021 case where we're basically trying to preserve those visas or do something so that DV 2021 doesn't get shut out based on the backlog. So do we know if any of the Go plaintiffs been scheduled for interviews?
I don't know.
Okay.
I'm not sure.
I will check with Aaron and get back to you all. I would be surprised if they have, to be honest with you, because DV 2021 is not a priority for Department of State. In fact, they've said that. In fact, consulates have been very transparent about that we are simply not scheduling DV 2021 cases. So I would be surprised, but I'll check with Aaron and get back to you. All right, another one. Charlotte. Hi, Charlotte. How are you? So Charlotte is just giving an update that we have 95 London participants in the mandamus lawsuit. We had a call of the impact litigation team yesterday, and I'm happy to announce that yesterday, when we only had 85, we had made a decision at that point that we are going forward with this lawsuit. So Greg Siskin's firm has already started working on it. Lily's going to be the lead attorney on this one. And she will be in touch with you all to make sure that your declarations are in shape and so that we can get it filed as quickly as possible. So good news on the mandamus lawsuit. It's not too late to join. You still have 1 day to join until tomorrow. If you need to know how to join that lawsuit, you can go to our website, which is immigrationissues.com. And there's an onboarding page on our website that you can go to, fill out all the information, make your payment, and then you're part of the lawsuit. All right, our K1 visa is going to be affected with this London shutdown. I already answered this, but I want to say it again just because it's sort of an unknown, right? It appears that the announcement that we got from travel.gov, which is the Department of State essentially, is that visas are shut down. But they didn't say immigrant visas or non-immigrant visas. They didn't specify. What we know anecdotally, because we're members of a bar association and we share information, is that it appears that these are only non-immigrant visas. And so I hope that K1s won't be affected, because the good news is that K1s, even though they're sort of a hybrid non-immigrant immigrant visa, they're processed by the immigrant visa units. So we're hoping that immigrant visas are not affected, number one, because they're tier 1, right? And number 2, because K1s are processed by the immigrant visa unit. So if you do get canceled, let us know. We would definitely want to know that, especially for the London mandamus lawsuit. All right. Is there a formal announcement that we can see somewhere regarding London? Yeah, it's on the Department of State website. You can also go to travel.gov, travel.state.gov, and it's on there as well. If one of you get a link to it, I can probably post that if you email it to me. Yes. Okay. Local conditions hampers and opening. Okay. This is just a general question, right? So this is a DV 2021 plaintiff from Nepal. What if local conditions mean that the embassy shut down or they slow processing? What happens then? Well, I'll answer it. Is that we have included a mandamus claim in Go, right? So if this happens, if local conditions either shut down the embassy or slow it down, that's the reason we have a mandamus claim in the complaint, is because, we're not only challenging the fact that DV 2021, these visas need to be adjudicated by September 30th, we're also adjudicating the delay and the failure to prioritize DV 2021. So if this happens, it just feeds our argument that the embassies and the consulates don't care about their mandate to process these cases by September 30th. So frankly, that would be good for us. Not good for us, but it would be fodder for our lawsuit if that happens. So again, keep us posted. All right, let's see. Okay, here's a Kinsley EB1 client, documentarily qualified. We're learning all these new terms that you all use in your parlance. DQed is documentarily qualified, December 2020. Do you think it's likely I'll get an interview this year? Depends on the consulate. It depends on a lot of factors. So it's impossible to tell you whether you'll get an interview this year. I mean, this year is 6 more months. So I would certainly hope that you would have an immigrant visa interview within the next 6 months, especially if you're part of the lawsuit. But I would also need to know where you're from, right? Because that's a big part of it. For example, if you're from, if you're from one of the consulates like Manila, it's going to be a problem. So that's important to let us know. All right, so this is a DV 2021 winner, case number 24,000. He wants to know his chances to get to the USA.
I mean, I think just like what you were saying for the last one, it's really hard for us to say, but we're going to keep fighting for it, and that's why we have the lawsuits involved for the DB visas, because we want to push the government to actually process these. We're really hopeful that we will be able to get through.
Yeah, I mean, the other thing I would say is your number really at this point is irrelevant because the visas are current, right? Right now, all the DV cases are current. So your number is not as important as getting through the door of the consulate, or if you're in the United States, filing your adjustment of status application. This is a race. And right now, all 55,000 of you are at the start line together, right? And so that's how you have to think of this, is you're at the start line together, the gun has gone off, and who's going to get there first. So it doesn't matter your number. What matters is how you get to the consulate. That's why we filed Go v. Blinken, right? We learned our lesson with Gomez and Aker. We were able to preserve visas in that case. And so, having learned the lessons from that, we're doing the same thing in Go v. Blinken. So, all right, let's see. What else do we have here? Here's one. Can a lawyer help for transferring a case for Go plaintiffs? He wants to hire us. Is this possible? Is it possible to transfer a case from one consulate to another?
Usually that depends on whether the consulate will accept it. So if you contact the consulate who you would like to transfer the case to, it's really up to their discretion in terms of whether they will accept the transfer or not. But it can be possible, usually in cases where you have some sort of a connection or a tie to that consulate where you'd like to transfer it. If it's just a totally random consulate, I would say the chances of being able to transfer it are probably less likely.
Yeah, I mean, if your consulate is shut down like London, I think you have a very compelling argument that you should be able to go to another consulate and you should ask for it. The other thing that we know is the Deputy Undersecretary for Consular Affairs, who basically that's the boss for all the consulates around the world. Her name is Juliet Stuff. And she publicly said that consulate transfers are absolutely possible. You can absolutely do them. And so, keep trying and, have a compelling reason and try it. Can you hire us to do it? Yes. But to be honest with you, it's not something you need an attorney to do. It's really just an email with the reason why you need to transfer. So, okay. Let's see. This is a good one. So who will get in first in line? So as you know, we have the Go case pending with Judge Mehta. Our brief is due on that case on Monday. Our response to the motion to dismiss and the motion for summary judgment is due on Monday. And then we are scheduled for oral arguments on July 13th. Meanwhile, there's been another case filed by Curtis Morrison, and that's the Goodluck case. I don't know, to be honest with you, whether he filed a motion to consolidate or even whether he let the court know that it's a related case to go. I don't know. Will it be consolidated? If that happens, I think it's likely that it will be consolidated. It's the same legal issue. So I think it will be consolidated. I think that's what the courts try to do for efficiency. The question is, who will have priority? Who will be first in line? Will it be Go plaintiffs or Goodluck plaintiffs? And I don't know. I mean, I don't know the answer to that. I think we are the lead case. We will be the lead case if it's consolidated with us. And so, yes, we will certainly argue that at a minimum, there should not be any priority for Goodluck. I mean, there should not be. If the judge is going to set priority, it should be Go, or it should be no priority anyway. I mean, it should be just whoever gets to the visa first. All right. Rylan, any update on the Ivy Cairo case, Abdullah?
Yes, great. So I did call this Monday, and it has been assigned to a U.S. attorney. But just like what we were saying with the other cases, for the K1 case, we are still waiting, and we are expecting them to file a motion to dismiss at the end of the 60-day period since filing. So we still have a while to wait, but at least we have opened up communications with the U.S. attorney, or I've left my contact information. I'm waiting for them to get back to me. But yeah, we are just sitting in line waiting, just like we have been for all the other mandamuses.
All right. So Craig wrote back and said, clarified that he's at the London consulate for his EB1 interview. So to me, this is a case where, you know, you've paid your visa fees. You've been approved by USCIS. The only reason that you're not getting your visa is because London has shut down. That is not your fault. That is not your problem. And so, yes, absolutely, I think you should try and get the case transferred. I don't know if Belfast would process EB1s, but that's probably where I'd start, is with Belfast. But other than that, you know, any country really, especially a country that you have connections to or where you've lived before or something like that, you should try. I think people that are in the European Union have probably a more compelling argument for moving their cases around. You know, one of the things about London is obviously the Brexit is a problem, but I think, yeah, I think you should definitely ask because there's nothing you can do about the fact that London shut down. Oh, this is a good one. I'm excited to post this one. Someone, sorry, I'm blanking you out there, Luke.
That's all right.
Jose Luis got scheduled he's a Go plaintiff and got scheduled yesterday. And another plaintiff also got scheduled. So the problem is they can't confirm the appointment since the ASC location don't have available dates. And it's not because they're not working. They're working on B1, B2s. I sent an email to consulate when they will be available for the ASC, and we'll update once we reply. Jose Luis, can you please send me an email with the details about the problem with the ASC? That is the first I've heard of that. So that the ASCs are a problem and that you're not able to schedule biometrics. So hopefully that's something that can get resolved really quickly. But I do need you to send me an email so that I can forward it to the government attorney. Okay. Okay, let's see. All right, strange things afoot in Russia. The KCC is telling the clients to contact other missions, but other missions are refusing case transfer. What to do? Well, I don't know why the KCC would be giving you that advice. That's weird. If Moscow gave you that advice, it'd be more reliable, but I don't think you should be relying on the advice of the KCC. I will tell you that Moscow has been processing visas. We've had plaintiffs that have been approved through Moscow. So I'm not sure whether transfer is going to be in your best interest in this case or not. The cases that have been transferred out of Moscow, what we know is they're transferred to Warsaw. Warsaw was accepting them for a while. I don't know if they're still accepting them. So certainly contact Moscow, ask them if it's possible. First of all, ask them if they will take your case and when they estimate they'll take it. And if you don't get a compelling answer, then try and get it transferred to Warsaw. Okay. All right. We've already answered this question, but I'll go over it again. We don't know. We think that it's only NIV. Anecdotally, those are the cases that have been canceled in August and September were all NIVs. We have not heard of any IVs. And we know that the K1s are processed in the IV unit. So we don't think they will be affected. For you got your F1 in the Bahamas and your H1 in London. Does it make sense to transfer your documentarily complete EB3 case to Bahamas from London? Again, if you're basing it on the shutdown, I don't think so, because apparently IVs are not affected. So, but if you're basing it on delays at the consulate versus Bahamas, that's a different story. Okay. And then finally, any comment, any news from the Rio consulate regarding EB5 visas? No, it's a Kinsley plaintiff from Brazil, but no, we haven't heard any news from the Rio consulate. I do not think that Rio has processed any visas on any Kinsley visas, but I'm not sure of that. We can look into that and get back to you. All right, any other questions before we tune out and end the broadcast? A little early today. We can give you 20 minutes of your lives back. All right. Well, please join us. Just a reminder, if you're a plaintiff in one of our cases, we have the standing call on Mondays at 6 p.m. Eastern, 4 p.m. Mountain. And then we always have this call, obviously, on Wednesdays at 12 p.m. Mountain, 2 p.m. Eastern. So join us anytime. Thanks.
Bye.